My name is James Graber. My practice area, well, there's a few. It's all litigation, though. I do property litigation, commercial litigation, and patent litigation. I'd say competitive. It's really as simple as that. I've been practicing almost 10 years now. Um, Practice has kind of evolved over the years. I started in property litigation, which is first party insurance, where maybe someone's suspected of arson or fraud, and the insurance company wants to investigate that and see if it's a legitimate defense or not. And I did that almost exclusively for 5-ish years, and it's kind of evolved since then. I handle product liability cases, car accidents, business breakups, copyright infringement, patent infringement. So I do a little bit of everything now in civil litigation. Well, I was an athlete in college. I ran track at UB, and a couple years in, I realized that was coming to an end, and I wanted to set myself up in a career as opposed to a sport that was predicated on competition. I'm competitive. I want to win, and I like having adversaries where you all want the same thing, and only one can have it. So I ended up choosing law, and to be completely honest with you, that probably was because I was obsessed with Jack McCoy at that time. So I went to law. That was probably a trial I had when I was an associate up in Niagara County. That I was only a couple years in, I think. So I was second sharing it with Tony Rupp. And it was just a slip and fall case. Somebody fell, hurt their shoulder, and it was a long trial. And one of our defenses was that the plaintiff was claiming he couldn't use his right arm. He had to learn how to write really with his left hand, and we kind of weren't buying that based on the evidence. So there were a lot of tense moments in the courtroom, and one of them, which we gave him a pen, and we said, all right, here's a sheet of paper, sign your name with your left hand. And he did, and it looked nothing like his signature, which kind of supported our defense, was that you didn't relearn how to do everything with your left hand. And it was a memorable case because there are a lot of really tense moments like that in the courtroom where you could like cut the tension with a knife. And I don't know, it's just one of my favorite parts of being a lawyer, really. Outside of work, well, I have 3 young kids, all 5 and under. I have a wife who's also a lawyer. I coach or am an attorney advisor for the Nichols mock trial team. There's a mock trial high school competition that's statewide, 300 to 400 schools that compete every year. So I do that every year. And I'm also the commissioner of actually the Lawyers Softball League in Western New York. There's like 14 to 16 firms who participate every summer. A legal tip. I would say anyone that's involved in a civil litigation case, up front when you're in that initial consult meeting with your attorney, talk to them about the timeline for your case. Because I think there's this misconception that I see a lot where someone sues you or you sue someone, and you're going to be in court in a month before a judge testifying under oath. And that may be true in criminal cases. You have a right to a speedy trial, but in civil cases it's a lot different, actually. I mean, you actually don't even get a judge assigned to your case right away in a civil case in New York State. You actually have to ask for one. Sometimes that doesn't happen for a year or two. And beyond that, there's this process called discovery, where you're entitled to ask people questions under oath, written questions called interrogatories. You're entitled to demand documents, take depositions, and that process sometimes can take months, if not years. So talk to your attorney up front about an anticipated timeline for your case whenever you're involved in a civil case, usually involving a dispute over money.